somebody telling one of the lobbyists that it was Gifted and Talented Day here this morning, and he said, "It's about time." In our defense, I walked up to him and I said, "I hope you return the favor." I will share their card with you later. So they're going to have a lot of free time for the next 80 days or so. The Senate will come to order. Senator Martinez-Humenick.
Thank you, Mr. President. Will those in the chamber and in the gallery please stand and join with me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, please call the roll.
Senators Aguilar, Baumgartner, Carroll, Cook, Crowder, Donovan, Garcia, Grantham, Guzman, Heath, Hill, Hodge, Holbert, John, Johnston, Johnston.
On Gifted and Talented Day, absent. What?
Jones, Kafalis, Kerr, Lambert, Lundberg, Marble, Martinez-Humenick, Merrifield, Neville, Newell, Roberts, Scheffel, Scott, Sonnenberg, Stedman, Tate, Todd, Ulibarri, Woods. Mr. President.
Here, with 34 present.
Looking for him. Where's leadership here?
With 34 present, 1 absent, 0 excused, we have a quorum. Senator Donovan.
Thank you, Mr. President. I move that the reading of the Journal of Wednesday, February 17th be dispensed with and the Journal be approved as amended by the Secretary.
You've heard the motion. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The motion is approved and the Journal is adopted. Please add Senator Johnson to the roll. Reports of committees of reference.
February 17, 2016, Committee on State Veterans and Military Affairs. After consideration, the Mayor's Committee recommends the following: Senate Bill 32 be postponed indefinitely. February 17, 2016, Committee on State Veterans and Military Affairs. After consideration, the Mayor's Committee recommends the following: Senate Bill 54 be postponed indefinitely. February 17, 2016, Committee on State Veterans and Military Affairs. After consideration, the Mayor's Committee recommends the following: Senate Bill 28 be postponed indefinitely. February 17, 2016, Committee on State Veterans and Military Affairs. After consideration, the Mayor's Committee recommends the following: Senate Bill 43 be postponed indefinitely. February 17, 2016, Committee on Judiciary. After consideration, the Mayor's Committee recommends the following: Senate Bill 42 be postponed indefinitely. February 17, 2016, Committee on Judiciary. After consideration, the Mayor's Committee recommends the following: Senate Bill 47 be postponed indefinitely. February 17, 2016, Committee on Judiciary. After consideration, the Mayor's Committee recommends the following: Senate Bill 48 be referred to the Committee of the Whole. Favorable recommendation. February 17, 2016, Committee on Judiciary. After consideration, the Mayor's Committee recommends the following: Senate Bill 65 be amended as follows and as so amended before the Committee on Appropriations with favorable recommendation. February 17, 2016, Committee on Judiciary. After consideration, the Mayor's Committee recommends the following: Senate Bill 110 be amended as follows and as so amended before the Committee of the Whole. Favorable recommendation with the recommendation be placed on the consent calendar.
Senate Services.
February 18, 2016, correctly printed, Senate Joint Resolution 8, correctly engrossed, Senate Bills 27, 30, 73, 89, 90, 91, 92, 93, 94, 95, Senate Joint Resolution 7, correctly re-engrossed, Senate Bill 51, correctly re-revised, House Bill 1044.
Introduction of resolutions.
Senate Joint Resolution 9 by Senator Martinez-Humenick and Representative Brown concerning the designation of February 2016 as Self-Care Month.
Majority Leader Scheffel.
Thank you, Mr. President. I move that the Senate lay over Senate Joint Resolution 9 to February 19.
You have heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. Senate Joint Resolution 9 will lay over until February 19th. Mr. Majority Leader.
Thank you, Mr. President. At this time, I move that the Senate proceed out of order for purposes of presenting a tribute.
The motion is that the Senate proceed out of order. All those in favor say aye. Opposed, no. The ayes have it. The Senate will proceed out of order. Senator Todd.
Thank you, Mr. President, and it brings me great honor today for us to welcome a special guest. The Senate of Colorado Legislature is so happy to welcome the Consul General from Japan, and I'm going to read a tribute to him, and then if you haven't had a chance to meet him yet, I encourage you to do so before the morning is over. The Senate of Colorado Legislature, convened in the second regular session of the 70th General Assembly, hereby extends heartiest congratulations and commendations to Consul General Makoto Ito, Consulate General of Japan in Denver. The members of the Colorado State Senate are happy to welcome Consul General Makoto Ito to the Senate floor and to his new position, as of May, to the Consul General of Japan in the Rocky Mountain region. We look forward to working with the Consul General and strengthening Colorado's economic and cultural ties with the nation of Japan. We are grateful for his service, and we offer our very best wishes in all his future endeavors. On request of Senator Nancy Todd, given this 18th day of February 2016, State Capitol, Denver, Colorado, Bill L. Cadman, President of the Senate. So please join me in welcoming him, and then I want to share a couple of comments about our relationship with Japan.
Consul General, welcome to our chambers. I had the honor of joining you at your home a few months ago, actually I believe it was July, as you presented one of our own from the other body, the Honorable William Hybl, the Order of the Rising Sun, which is a very rare recognition for anybody, frankly, around the planet, signed by the Emperor. So thank you for joining us, and thank you for the recognition of someone substantial, not just in our state, but around the world. Senator Todd.
Thank you, Mr. President. And a couple of things that I think, and you all may be seated. Thank you, you all. All of you may be seated. Basically, Colorado was a destination for Japanese Americans during and after World War II, and thanks to the state's governor at that time, Governor Ralph Carr believed it was unconstitutional to imprison Americans and welcome Japanese Americans to Colorado. We have the beautiful Carr Center across the street in honor of a man who stood his ground and who made it very clear that all people are equal and should be treated with dignity. Japan is Colorado's fourth largest export market and has been for the last 5 years. More than 50 Japanese or Japan-based companies maintain branches here in our beautiful state of Colorado. There's a large active Japan-related community in several areas of the state, including the Japan America Society, Japanese American Citizens League, Sister Cities International, and several others. Colorado is partnered with Yamagata Prefecture as its sister state, and throughout the state, Colorado cities enjoy strong sister cities relationship with cities in Japan. The nation of Japan is an invaluable political and financial ally in global issues, including development assistance, combating communicable disease, and protecting the environment and natural resources. We are thrilled to have the new Consul General. We were sad to see your predecessor leave, but we are thrilled to have you join us. And again, I encourage all of you to please make your way over and say hello and give greetings. And perhaps one of your cities has a sister city with Japan as well. Thank you very much for your time, colleagues.
Colleagues, we will take a recess so that we can welcome and greet our special guest. Thank you again, Consul General. The Senate will be recessed. Senate Bill 130 is assigned to the Committee on Finance.
Senate Bill 131 by Senators Tate and Representatives Pabon and Willett, concerning the management of assets for individuals and in connection therewith clarifying that a fiduciary's authority is suspended after a petition for the fiduciary's removal is filed, protecting an adult ward or a protected person's right to an attorney post-adjudication, and preventing a fiduciary from paying court costs or fees from out in a state after receiving notice of an action for the fiduciary's removal.
Senate Bill 131 is assigned to the Committee on Judiciary.
Senate Bill 132 by Senator Cook and Representative Foote, concerning clarifying that test results relating to certain DUI offenses are not public information.
Senate Bill 132 is assigned to the Committee on Judiciary.
Senate Bill 133 by Senator Tate and Representatives Pabon and Willett, concerning the transfer of property rights upon the death of a person in connection therewith, including inherited individual retirement accounts and inherited Roth individual retirement accounts as property exempt from levy and sale under a writ of attachment or writ of execution, clarifying determination of heirship proceedings and probate, and enacting portions of the Uniform Power of Appointment Act.
Senate Bill 133 is assigned to the Committee on Judiciary.
Senate Bill 134 by Senators Heath and Garcia and Representatives Danielson and Kagan, concerning professional licensing for military veterans in certain professions.
Senate Bill 134 is assigned to the Committee on Business, Labor, and Technology.
Senate Bill 135 by Senator Aguilar and Representative Janal, concerning a pharmacist provision of healthcare services that have been delegated by another healthcare provider.
Senate Bill 135 is assigned to the Committee on Health and Human Services and the Committee on Finance. Third reading of bills, consent calendar. Mr. Mazurs, would you please read the title of all the bills on the third reading of bills consent calendar? Colleagues, we are on third reading. This is typically when we get quiet. So I'm speaking to all 70 colleagues today.
Senate Bill 27 by Senators Martinez, Mendigatata, Representative Primavera, and Landgraf, concerning allowing the option for Medicaid clients to obtain prescribed drugs through the mail and in connection therewith reducing an appropriation. Senate Bill 30 by Senator Hodge, Representative Tyler, concerning the surcharges for violating motor vehicle weight limits and in connection therewith making an appropriation. Senate Bill 89 by Senator Lambert and Representative Hamner, concerning the establishment of an alternative maximum reserve for the Department of State Cash Fund. Senate Bill 91 by Senator Lambert and Representative Hamner, concerning timing of the statewide discovery sharing system. Senate Bill 92 by Senator Grantham and Representative Rankin, concerning the authorization of the state to act pursuant to the Federal Oil Pollution Act of 1990. Senate Bill 93 by Senator Lambert and Representative Young, concerning transfer of the oversight of independent living services from the Department of Human Services to the Department of Labor and Employment. Senate Bill 95 by Senator Stamen and Representative Young, concerning the 5-year appropriations requirement for bills that change the periods of incarceration in state correctional facilities.
Majority Leader Shuffle.
Thank you, Mr. President. I move that the Senate adopt all the bills listed on the third reading of bills for final passage consent calendar, which includes Senate Bill 27, Senate Bill 30, Senate Bill 89, Senate Bill 91, Senate Bill 92, Senate Bill 93, and Senate Bill 95.
The motion before the body is the adoption of all of the third reading bills on the consent calendar. Is there any discussion on any of the bills? Senator Lundberg, Senator Sonnenberg, Senator Crowder, Senator John, Senator Carroll, Senator Kerr, Senator Merrifield, Senator Baumgardner, Senator Roberts, Senator Aguilar, Senator Cook, Senator Grantham, Senator Lambert, Senator Holbert, Senator Johnston, Minority Leader Guzman, Senator Donovan, Senator Hodge, Senator Garcia, Senator Jones, Senator Scott, Senator Newell, I see you consulting about co-sponsoring. You don't need to do that. Over here. With 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 30 is adopted. Co-sponsors: Senator Woods, Senator Baumgardner, Senator Scott, Senator Cook, Senator Marble, Senator Grantham, Senator Sonnenberg, Senator Lambert, Senator Lundberg, Mr. Majority Leader, Senator Todd, with 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 89 is adopted. Co-sponsors: Mr. Majority Leader, Senator Cook, Senator Lundberg, with 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 91 is adopted. Co-sponsors: excellent. With 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 92 is adopted. Co-sponsors: Senator Crowder, with 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 93 is adopted. Co-sponsors: Senator Kafalis, Senator Hodge, Senator Heath, Senator Newell, Senator Merrifield, Senator Todd, Senator Garcia, Senator John, Senator Woods, Senator Cook, Senator Martinez-Humenic, Senator Lundberg. Chief Sergeant of Arms, that'll be $10. With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 95 is adopted. Co-sponsors: Minority Leader Guzman, Senator Jones, Senator Heath, Senator Merrifield, Senator Todd, Senator Lundberg, Senator Kerr, Senator John, Senator Hodge, Senator Kafalis. Third reading of bills, final passage. Mr. Majors, would you please read the title to Senate Bill 94?
Senate Bill 94 by Senator Crowder and Representative Vehil, concerning the shared costs of a district public health agency by the counties in the district.
Senator Crowder.
Thank you, Mr. President. I move SB 16094 and ask for a favorable vote on it. Thank you.
Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 94 is adopted. Co-sponsors: Senator Roberts, Senator Heath, Mr. Majority Leader, Madam Minority Leader, Senator Aguilar, Senator Kafalis, Senator Lundberg, Senator Martinez-Humenick, Senator John, Senator Holbert, Senator Stedman, Senator Newell, Senator Scott, Senator Grantham, Senator Todd, Senator Lambert, Senator Donovan, Senator Johnston, Senator Baumgardner, Senator Merrifield, Mr. Majors, would you please read the title to Senate Bill 73?
Senate Bill 73 by Senator Grantham and Representative Lawrence, concerning the authority of the state auditor to audit the use of state gaming tax revenues transferred from the state historical fund directly to the gaming cities for historic preservation.
Senator Grantham.
Thank you, Mr. President. I move for the adoption of Senate Bill 73 on third reading and final passage and ask for use of the present roll call.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 73 on third reading. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 73 is adopted. Co-sponsors: Senator Jones, Majority Leader Scheffel, Senator Heath, Minority Leader Guzman, Senator Lambert, Senator Holbert, Senator Stedman, Senator Woods, Senator Lundberg, Senator Marble, Senator Kerr. Senator Todd. Senator John. Senator Baumgartner. Senator Garcia. Senator Scott. Senator Crowder. Senator Kafalis. Senator Merrifield. Senator Sonnenberg. Senator Cook. Senator Neville. Senator Martinez-Humenick, and an assist for Senator Sonnenberg.
Be afraid.
Mr. Majors, would you please read the title of Senate Bill 90?
Senate Bill 90 by Senator Stedman, Representative Young, concerning the ability of the Department of Public Health and Environment to collect data on marijuana health effects at a regional level.
Senator Stedman.
Thank you, Mr. President. I move Senate Bill 90 on third reading and final passage and suggest the use of the present roll call.
Is there further discussion? Senator Lambert.
Thank you, Mr. President. I also ask for an aye vote on Senate Bill 90. The issue here, members, is that it's very difficult for some very small counties to collect this data. It's not practical, and this allows some of that data to be collected at a regional level. I'd ask for an aye vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 90 on third reading and final passage. Are there any no votes? Senator Sonnenberg. With 34 ayes, 1 no, 0 absent, 0 excused, Senate Bill 90 is adopted. Co-sponsors. Senator Tate, Minority Leader Guzman, Senator Ulibarri, Senator Heath, Senator Crowder, Senator Roberts, Senator Merrifield, Senator Todd, Senator Kafalis, Senator Martinez-Humenick, Senator John, Senator Jones, Senator Johnston, Senator Newell, General Orders, second reading of bills. Majority Leader Scheffel.
Thank you, Mr. President. At this time, I'm going to make a motion to take up special orders consent calendar. Colleagues, these bills are going to be comprised of the supplementals that have come out of appropriations yesterday. This has been discussed with leadership on the minority side. So at this time, thank you, Mr. President. I move that the Senate take up the following bills: House Bill 1237, House Bill 1238, House Bill 1239, House Bill 1240, House Bill 1242, House Bill 1243, House Bill 1244, House Bill 1245, House Bill 1246, House Bill 1248, House Bill 1249, House Bill 1250, House Bill 1251, and House Bill 1252 on a special orders second reading consent calendar at the hour of 9:50.
You have heard the motion that the Senate proceed with a special orders calendar, general orders, second reading of bills. This takes a 2/3 vote. All those in favor say aye. Aye. Opposed, no. The ayes have it. We're preparing the calendar. Having arrived at the hour of 9:50, the Senate will proceed with the special orders second reading of bills consent calendar. Soon as good. Senator Grantham.
Thank you, Mr. President. I would move that the Senate resolve itself into the Committee of the Whole for the consideration of special orders, second reading of bills, consent calendar.
You have heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. The Senate will proceed with special orders, second reading of bills, consent calendar will, as the Committee of the Whole, and Senator Grantham will take the chair. The time is what we say the time is. It's all what's in the book.
The committee will come to order and the court rule is relaxed. Mr. Majors, would you please read the titles to all the bills on the consent calendar?
House Bill 1237 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation in the Department of Agriculture. House Bill 1238 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation in the Department of Corrections. House Bill 1239 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation in the offices of the Governor, Lieutenant Governor, and State Planning and Budgeting. House Bill 1240 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation in the Department of Healthcare Policy and Financing. House Bill 1242 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation in the Department of Human Services. House Bill 1243 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Judicial Department. House Bill 1244 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Law. House Bill 1245 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Military and Veterans Affairs. House Bill 1246 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Personnel. House Bill 1248 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Public Safety. House Bill 1249 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Regulatory Agencies. House Bill 1250 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of Revenue. House Bill 1251 by Representative Hamner, Senator Lambert, concerning a supplemental appropriation to the Department of the Treasury. House Bill 1252 by Representative Hamner, Senator Lambert, concerning funding for capital construction and making supplemental appropriations in connection therewith.
Majority Leader Scheffel.
Thank you, Mr. Chairman. At this time, I move that the committee adopt all the bills on the special orders second reading of bills consent calendar, which includes House Bill 1237, House Bill 1238, House Bill 1239, House Bill 1240, and its associated Appropriations Committee report, House Bill 1242, House Bill 1243, House Bill 1244, House Bill 1245, House Bill 1246, House Bill 1248, House Bill 1249, House Bill 1250, House Bill 1251, and House Bill 1252. Ask for an aye vote.
Is there any discussion on the committee report for House Bill 1240? Seeing none, the motion before the body is the adoption of all the reports to all the bills on the special order, second reading of bills consent calendar. All those in favor say aye. All opposed say no. The ayes have it, and those reports are adopted. Is there any discussion on any of the bills listed on the special orders consent calendar? Seeing none, the motion before the body is the adoption of all the bills on the special orders, second reading of bills consent calendar. All in favor say aye. All opposed no. The ayes have it and the bills are adopted. Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee rise and report.
Motion before the body is for the committee to rise and report. All those in favor say aye. All opposed, no. The ayes have it, and the committee will rise and report.
You guys didn't need that keyboard or any of those electronics, did you? What's that smoke? And the other side? No, because I was working over here then. And you should more. The Senate will come back to order. Senator Grantham.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Mr. Majors, would you please read the report?
February 18, 2016, Mr. President, your committee holds reports under consideration of the following types of bills, making second reading thereof, makes following recommendations thereon. House Bill 1237, House Bill 1238, House Bill 1239, House Bill 1240 as amended, House Bill 1242, House Bill 1243, House Bill 1244, House Bill 1245, House Bill 1246, House Bill 1248, House Bill 1249, House Bill 1250, House Bill 1251, House Bill 1252, passed on second reading in order to revise and placed on the counter for third reading and final passage.
Senator Grantham.
Thank you, Mr. President. I move for the adoption of the report.
The motion before the body is the adoption of the report of the Committee of the Whole. Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the report of the Committee of the Whole is adopted. House Bill 1237, 1238, 1239, 1240 as amended, House Bill 1242, 1243, 1244, 1245, 1246, 1248, 1249, 1250, 1251, 1252 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Majority Leader Scheffel.
Thank you, Mr. President. In a minute here, I'm going to do a second motion that the Senate take up special orders on second reading. Colleagues, this is going to be a regular second reading with some discussion. There were a couple of what JBC is referring to orbital bills that came through with the supplemental package that they wanted to not do on consent that's going to require some discussion. So with that, Mr. President, I move that the Senate take up two bills, House Bill 1253 and House Bill 1254, as part of a special order second reading of bills calendar at the hour of 9:56.
Maybe you haven't heard. You have heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. Having arrived at the hour of 9:56, the Senate will take up special orders, second reading of bills, to include the bills House Bill 1253 and 1254. Senator Grantham.
Thank you, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for the consideration of special orders, second reading of bills calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of special orders, second reading of bills. Senator Grantham will take the chair.
The committee will come to order and the court rule is relaxed. Mr. Majors, would you please read the title to House Bill 1253?
House Bill 1253 by Representative Hamner, Senator Stedman, concerning adjustments to the amount of total program funding for public schools for the 2015-16 budget year and in connection therewith making and reducing an appropriation.
Senator Stedman.
Thank you, Mr. Chairman. I move House Bill 1253. There is no committee report.
To the bill.
Thank you. Colleagues, this is the supplemental bill for the Department of Education this year. There were no other supplemental adjustments to the department's budget other than the school finance total program line. And what's going on in this bill is we're making a couple key adjustments to school funding for the current budget year. And these adjustments are a result of new information that we received after we passed last year's School Finance Act, and specifically, the local mill levy property tax collections came in quite a bit higher than had been anticipated. So the local share contribution to school finance was greater than we had projected, and that enables us to make an offsetting reduction to the state share of school finance to the tune of $93 million. The other adjustment we're making is that last year the pupil enrollment estimates for the School Finance Act were overestimated. And when we did the October count this fall, there were fewer pupils in the enrollment count in our public schools across the state, and fewer of those pupils qualified as at-risk students for additional at-risk funding than had been projected last year when we built the School Finance Act. The net result of this bill is to allow the school districts to keep the extra money from the overestimation of enrollment. That amounts to $24.5 million of additional funding that's being made available to school districts in the current budget year. That is approximately $18.28 per pupil for the average school district. That's how much their PPR will increase by as a result of this bill. But really, the reason for the bill is that our negative factor in the School Finance Act is expressed in statute, and anytime we make adjustments to school finance that affect the negative factor, we have to change the statute, and that's what House Bill 1253 does. It reduces the negative factor in the School Finance Act by $24.5 million in the current year, bringing the approximate value of the negative factor down to about $831 million now. It was previously at $855. We're slowly but surely making some progress towards reducing or eliminating it. The bill also makes no change to current statute, which directs the Joint Budget Committee to set the budget each year based upon an assumption that the negative factor will remain constant. And so with this reduction in the negative factor that's occurring in House Bill 1253, this will become the mark that the Joint Budget Committee will strive to meet in setting appropriations for the next budget year of keeping that negative factor flat at $831 million. But the net takeaway from this bill is more money for schools in the current year, an increase of over $18 per pupil in funding, a $24.5 million reduction in the negative factor. I'd ask for your aye vote.
Senator Lambert.
Thank you, Mr. Chair. This is actually one of the most important orbital bills we'll see concerning the budget this year. As the senator from Denver just said, because of the lower student count, because of increased revenue, because of increased assessments of housing, that increased property taxes, this is kind of a rare opportunity to basically ratchet up our spending a little bit for K-12. It does help the schools, but I think this is part of an overall long-term strategy that we've discussed in the Budget Committee for several years, especially due to the good analysis of our JBC staff member, Craig Harper. We're looking at a multi-year strategy for funding schools, actually from our state funding, more with general fund instead of one-time money. That's a very important part of this. This is just one element of that philosophy. So when you can actually increase per pupil funding, decrease the negative factor, make our state more reliant upon our general fund for our state K-12 contribution to K-12 education, I think it's a good thing. So we did not put this on the consent calendar because we wanted to have a chance to talk about it, answer any questions that you might have about this. But I think in the long term, this is a very good strategy, and I'd ask for an aye vote on the bill.
Senator Holbert.
Thank you, Mr. Chairman. I concur with the prior senator, speaker. This is an opportunity, I think, for all of us to recognize the function and I think the good work of the Joint Budget Committee. Our requirement to operate on a balanced budget is a challenge for those 6 people. But in this case, on this particular supplemental bill, we do get to recognize an increase in per pupil funding for our K through 12 environment, and also how those 6 people who are charged with this incredible responsibility, not only to run supplemental bills and make sure that our current year budget comes in on balance, but looking ahead and how that affects next year. I want to take the opportunity to come up and tell our 3 members of the JBC thank you, and that includes you, Mr. Chairman. And as hard as it is to recognize that the House actually might have done something right, thank you to the 3 representatives that served on Joint Budget Committee. I really appreciate, on behalf of K through 12 education statewide, thank you very much for your efforts.
You are always in order when offering praise and adulation to the Joint Budget Committee. Is there any further discussion? Seeing none, the motion before the body is the adoption of House Bill 1253. All those in favor say aye. All opposed say no. The ayes have it, and the bill is adopted. Mr. Majors, would you please read the title to House Bill 1254?
House Bill 1254 by Representative Young and Senator Grantham concerning post-board training concerning wrongs to persons with intellectual and developmental disabilities.
Senator Grantham.
Thank you, Mr. Chair. I move House Bill 1254.
To the bill, Senator Grantham.
Thank you, Mr. Chair. This is the second of the 2 special orders bills, colleagues, for that the Joint Budget Committee is bringing over with the supplemental package. Again, this one, like the previous one, deserved a little bit extra mention and a little bit more explanation as far as what we're doing here. In relation to a task force that we had over this last interim period in regard to the IDD population and in regard to Senate Bill 109 from last year, that Senate Bill 109 had to do with the mandatory reporting, abuse reporting for adults with disabilities. That bill expanded the mandatory reporting requirements for these at-risk adults to cover known or suspected abuse of these at-risk adults with intellectual and developmental disabilities. As I mentioned, 109 created this task force, and one of their recommendations that came across was that the post board should develop and conduct some training related to the investigation of the mistreatment of these individuals with intellectual and developmental disabilities. And part of that is what this bill is trying to accomplish, requiring the post board to create and implement a training curriculum to prepare the peace officers to recognize so that they can more adequately address incidents of abuse and recognize them, any exploitation of at-risk adults with intellectual developmental disabilities, and requiring them to do this by June 30th of this year. Specifically, we are requiring them to create and implement this training curriculum by the end of this fiscal year, June 30, and also to create and implement the training referenced in that requirement within existing appropriations. So this is not going to cost any extra for the 15-16 year or the following year. And I would just simply ask for your aye vote, folks. This is a great bill in conjunction with what we just recognized this week with the IDD community. And I believe, as the senator from Denver mentioned during that recognition, it's not something that we should just focus on one day, but every day. This is a population that genuinely needs our help, and I think we can get agreement on that on both sides of the aisle. Ask for an aye vote.
Senator Newell.
Thank you, Mr. Chair. I rise in support of House Bill 1254 and thank my colleagues for bringing it forward. This is so prevalent, not only because we are now getting increased reports. You might check with your own counties, but in Arapahoe County and Denver, we have seen increased calls into adult protective services and into law enforcement. And so this is so apropos for that reason, but also you might have seen in the news just last night in Denver, there was a Special Olympics athlete who on the street was attacked and beaten. There are definitely ways that we all can have more training in looking at the at-risk, both the youth and the adults, but how important it is and how relevant it is for us to be doing this right now at this particular time in our state, and I really thank you for bringing it forward. And so I am a strong supporter of 1254.
Senator Lambert.
Thank you, Mr. Chair, and I have to do this with some trepidation because I don't really want to give any credit to the bill sponsor because he's not currently in the chair. But this is an important bill, members. We did talk about the IDD population yesterday. We've had, I think, a great deal of reform in our state concerning this population, other disabled and handicapped population. And this is one that is particularly abused and exploited in our society, which is a shame. It's a shame on our society that these things happen. But when people do get into trouble and need help, it's very important that our law enforcement officers are viewed as a source of help for them. And, you know, the natural tendency is for people to be afraid of going to law enforcement for this kind of abuse. We have discussed, in some cases, mandatory reporting of people who come in contact with IDD populations. But it's important when investigations are taking place or when street crime takes place that our law enforcement know how to handle people with intellectual disabilities and present a comfortable environment for them to discuss their particular needs. So I think this is an important bill, and I'd ask for an aye vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of House Bill 1254. All those in favor say aye. Those opposed, no. The ayes have it, and the bill passes.
Majority Leader Shuffle.
Thank you, Mr. Chairman. I move the committee rise and report.
Motion before the body is for the committee to rise and report. All those in favor say aye. All opposed, no. The aye has it, and the committee will rise and report.
The Senate will come back to order. Senator Grantham.
Thank you, Mr. President. The committee has had 2 bills under consideration. Mr. Majors, would you please read the report?
February 18, 2016, Mr. President, your committee whole brings the reports under consideration. The following tax bills being second on the reading thereof makes following recommendations are on. House Bill 1253, House Bill 1254, passed on second reading in order to revise, placed on account for third reading and final passage.
Senator Grantham.
Thank you, Mr. President. I move for the adoption of the report.
The motion before the body is the adoption of the report of the Committee of the Whole. Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the report of the Committee of the Whole is adopted. House Bill 1253, House Bill 1254 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Message from the House.
February 18, 2016, Mr. President, the House has passed on third reading transfer with advisory statute, House Bill 1083, 1067, 1169, 1151. The House passed on third reading transfer with advisory statutes, House Bill 1120 is amended, 1148 is amended, 1122 is amended. The House has passed on third reading, returns herewith, Senate Bills 15 and 9. The House has postponed indefinitely Senate Bill 11. The bill is returned herewith.
Message from the Reviser.
February 18, 2016, we herewith transmit without comment House Bills 1067, 1083, 1151, and 1169 without comment as amended, House Bills 1120, 1122, and 1148.
Senator Grantham.
Thank you, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for the purpose of General Order's second reading of bills calendar.
The motion before the Senate is to resolve itself into the Committee of the Whole. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of General Order's second reading of bills. Senator Grantham will take the chair.
Committee will come to order and the court rule is relaxed. Mr. Majors, would you please read the title of Senate Bill 7?
Senate Bill 7 by Senator Roberts concerning the establishment of a multiplier in the renewable energy standard for electricity generated from certain types of biomass to provide an incentive to use materials located within areas that have a high risk of wildfire.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 7 to February 23.
Motion before the body is for the Senate to lay, or for the committee to lay over Senate Bill 7 to February 23rd. All those in favor say aye. Aye. All opposed, no. The ayes have it, and that will be laid over. Mr. Majors, would you please read the title to Senate Bill 121?
Senate Bill 121 by Senator Tate and Representative Garnett concerning the percentage of tuition revenue that an institution of higher education is authorized to pledge for contracts for the advancement of money.
Senator Tate.
Thank you, Mr. Chair. I move Senate Bill 16-121 and the Finance Committee report.
To the committee report.
In the committee, we added the petition clause to the bill, and that was the only change to the bill language.
Is there any further discussion on the Finance Committee report? Senator Kerr.
Thank you, Mr. Chair. I was just wondering if we could have an explanation about why that particular amendment was passed in the Finance Committee.
Senator Tate.
Thank you, Mr. Chair, and thank you, Senator Kerr, for that question. It was passed because originally it had a safety clause on it, but, you know, we're talking about restructuring debt issues, institutions taking on debt, and when any institution or organization has a plan to get involved in a debt offering, they can always purchase a forward contract and plan for that. And therefore, we determined that this particular bill was not necessary for the immediate preservation of public peace, health, and safety. Thank you.
Is there any further discussion on the Finance Committee report? Seeing none, the motion before the body is the adoption of the Finance Committee report. All those in favor say aye. All opposed, no. The aye has it, and the Finance Committee report is adopted. To the bill.
Thank you, Mr. Chair. This is an important bill. I'll just read the title, and it is concerning the percentage of tuition revenue that an institution of higher ed is authorized to pledge for contracts for the advancement of money. And this bill is very important because it deals with how higher education institutions can manage their debt. The ability of a higher education institution to take on debt and the amount of debt a higher education institution can take on is based on its overall debt service capability, and that's based on its overall revenue stream and the amount of the revenue, its overall revenue stream that it apportions to debt service. In addition, two other primary drivers are an institution's credit rating, and our higher education institutions all have different credit ratings. And then finally, general ratio of debt to assets. Those three determinants are what overall informs an institution's ability to take on debt. This current provision in statute that we're seeking to address here is kind of a liquidity disruptor. What happens is it affects the pricing of credit to a higher education institution for which the credit rating or its overall debt service ratio is not a determining factor. Therefore, our higher education institutions that are not participating in the Intercept program are paying a premium for debt. And by one estimate, the University of Colorado can save in present value terms, in terms of future interest costs, over $20 to $30 million. And I ask for an aye vote to this bill. Thank you.
Is there any further discussion? Senator Hill.
Thank you, Mr. Chair. Colleagues, this is a great opportunity for us to really do more with less, to get government out of the way that allows us to provide more money for our CU system, who I hope my children go to someday, who happen to be standing in the back as well. But I hope my children go to CU someday, and this offers the opportunity for CU to hopefully lower tuition rates, keep those lower, because we're getting out of their way and allowing them to manage their finances more efficiently.
Is there any further discussion? Senator Johnston.
Thanks, Mr. Chair. I just wanted to add a clarification for folks who weren't on committee. Important to note, this does not expand the amount of bonding or borrowing capacity that CU takes out. So for your fears are, wait a sec, does that mean that they're going to more significantly leverage the amount of money they're borrowing and leverage it against tuition rates? It doesn't. It simply says it allows them to bond on the total capacity that they have. The way it stands now, it would be like saying you can only take out a mortgage on 10% of your house's worth. What you want to be able to do is have an accurate reflection of what the university has in assets and then bond against that. There is still an absolute requirement that they can't ever bond more than 10% of the total revenues that they have, and they're already well below that, around 7%. So just to be clear, saves them money, saves students money, but in the process doesn't take any greater risks for the university or the public funds. I'd ask for an aye vote.
Is there any further discussion? Senator Tate.
Thank you, Mr. Chair. I just want to thank my colleagues for the support of the bill, and I look forward to helping our higher education institutions deliver better value to students.
Is there any further discussion on Senate Bill 121? Seeing none, the motion before the body is the adoption of Senate Bill 121. All those in favor say aye. All opposed, no. No! The noes have it, and that bill fails miserably. Mr. Majors, please read the title to Senate Bill 17.
Senate Bill 17 by Senator Neville and Representative Neville concerning allowing a law-abiding person to carry a concealed handgun without a permit in connection therewith preserving current laws restricting the carrying of concealed handguns on certain property, including school grounds.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move that the committee lay over Senate Bill 17 to the end of the general order's second reading of bills calendar.
You've heard the motion. The motion is to lay over Senate Bill 17 to the end of the general order's second reading of bills calendar. All those in favor say aye. All opposed, no. The ayes have it, and that will lay over to the end of the calendar. Mr. Majors, would you please read the title to Senate Bill 34?
Senate Bill 34 by Senator Sonnenberg concerning tampering with a deceased human body.
Senator Sonnenberg.
Thank you, Mr. Chair. I move Senate Bill 34 and the report on the Committee on Judiciary.
Is there also an Appropriations Committee report?
And the Appropriations Committee report. My apologies, Mr. Chair.
To the Judiciary Committee report.
Thank you, Mr. Chair. The Judiciary Committee report just struck out a section that had to do with viewing.
Is there any further discussion on the Judiciary Committee report? Seeing none, the motion before the body is the adoption of the Judiciary Committee report. All those in favor say aye. All opposed, no. The aye has it, and the report is adopted. To the Appropriations Committee report.
Thank you. No comments on the Appropriations Committee report.
Is there any further discussion on the Appropriations Committee report? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. All opposed, no. The ayes have it, and that report is adopted. Senator Sonnenberg to the bill.
Thank you, Mr. Chair, and I'll be short and sweet. This bill is to make sure that the penalty for tampering with a body actually reflects the crime. Right now, tampering with a body, and we had a number of people testify on how this might have been helpful to them and their district attorneys and law enforcement. There's no difference between wiping a fingerprint off of a glass or removing a dead body. That should change. If we tamper with a dead body as part of an investigation or hide evidence with a dead body, that needs to be a stiffer crime, and I am asking you to vote yes to help make that a stiffer crime.
Senator Stedman.
Thank you, Mr. Chairman. And colleagues, I rise with some serious concerns about this bill. And I, one, was curious to hear the sponsor's explanation of the problem that we're trying to solve, or what's the objective for making this change. Because if you look at the bill, you'll see that it makes changes to the current crime of tampering with physical evidence. That is currently a crime today, and yet Senate Bill 34 would remove tampering with a dead body from the ambit of what is considered tampering with evidence. So that Senate Bill 34 would be the only way of punishing people for the crime of tampering with a dead body. So let's look at the proposed new crime that Senate Bill 34 creates. It says a person creates tampering with the deceased human body if, believing that an official proceeding is pending, in progress, or about to be instituted, and acting without legal right or authority, the person, and then goes on to tamper with the body. So one of the elements of the crime that we're constructing here is that the defendant, the actor, must believe that some official action is pending, in progress, or about to be instituted. How's that going to be proved? You know, I've worked for a lot of years on the criminal code and heard a lot of debates about criminal statutes where people have been afraid of creating elements of crimes that requires the police and the district attorney to become the thought police and get inside the actor's head to try to figure out what were they thinking or what were they believing, in the words of this statute, at the moment they committed the crime. And here we go again. And, you know, I think I've been on all sides of this issue, but it's interesting to see the tables turn. Here's my bigger concern. If the law enforcement and the district attorney is able to prove that the actor believed this dead body had some official proceeding that was pending, in progress, or about to be instituted, and they went on to tamper with the body, let's look at how Senate Bill 34 proposes to punish them. And this is all at the top of page 3 of the bill. There's the punishment scheme where your act of tampering is going to be punished at a different level of felony classification depending on the circumstances of how the dead body came to be a dead body. If it was a Class 1 felony murder, then the punishment for tampering is more severe than if the dead body were the result of criminally negligent homicide. And it says in the bill, and the way it's constructed, that for me to be punished with tampering, someone else has to be charged with the underlying homicide. So what happens if I'm a really good dead body tamperer and I do such a good job tampering and concealing the dead body that the person that killed the person never is caught, never is apprehended, and never is charged? How would I be punished? Colleagues, this is a glaring loophole in this law. I think there are some other things we could point out, questions as to what if two people committed the homicide and yet one of them had diminished mental capacity so that they would be charged with a lesser classification of homicide than the person who perhaps murdered the decedent. How am I to be charged for tampering when the two defendants that caused the homicide are charged under different provisions of the criminal code? This is not harmonized. Folks, I believe the sponsor when he says he's really trying to cause a problem or solve a problem and create a way to have a more serious penalty for, as he said, tampering with a body versus tampering with fingerprints. But this is not the way to do it. This statutory scheme has some really scary loopholes in it. I think we're better off sticking with the current law where tampering with evidence is already a crime, and we're not making the punishment for this new crime dependent upon actions in the future for which the police and the district attorneys may have no ability to control. This is a problem. I would suggest this bill needs to go back to the drawing board. I'll be voting no.
Senator Sonnenberg.
Well, thank you, Mr. Chair, and let me address a couple of those concerns, or the two concerns. The first one, well, let me start with the second one. That was the one that was brought up in committee with the scaled different penalties. There was concern brought up that perhaps we ought to have just one penalty. And we had talked about a second-degree felony for all of those crimes, including tampering with the body. If we have a second-degree felony on a crime such as manslaughter, which is a fifth-degree felony, we would be implementing a much stricter penalty on the tampering than the crime itself. We modeled the penalty aspect of this bill with those statutes that talk about being an accessory to a crime. We do the same thing. If you're an accessory to a misdemeanor, the penalty for your crime for being an accessory is different than if you are an accessory to a felony. It's different than if you're an accessory to a first-degree felony than a fifth-degree felony. Now, we talked about that. The district attorneys, those in law enforcement said, you know, we're happy to not have that discretion. If you want to make it a second-degree felony, like a few of my friends on this side of the room wanted me to do, they're happy with that. But does that really make sense? Does it make sense to have a second-degree felony or even a third-degree felony applied to a crime that might be a fifth-degree felony, which is the original crime? That's why I think the sliding scale is appropriate. I think the sliding scale is just like the accessory to a crime statutes, and it works very well for us in that aspect. There is no difference. Now, the first question had to deal with how do you get in somebody's head to realize whether a person is tampering with a deceased human body, believing that an official proceeding is pending, in progress, or about to be instituted. Ladies and gentlemen, this isn't rocket science. If you have a dead body in front of you, there's probably something that's going to be happening. There's probably an investigation that's going to need to be done. This is meant to help with those law enforcement issues in which somebody has killed somebody and can't dispose of the body by themselves, so they enlist somebody else's help. When they enlist somebody's help, and right now it's a misdemeanor for that somebody to help, there is no hammer to help get them to talk. We have created an accessory. We have created somebody, a separate crime in which somebody is helping with a felony, but it's a misdemeanor to help. So when law enforcement says, look, we know you had a part in this. We know you were participating in this process. Right now, it's hard to use a hammer in law enforcement to be able to say, look, talk to us. Help us get this family some resolution. Help us find this body. And if you help us find this body, right now you can't plea bargain from a misdemeanor down to much lower. But what you can do is if you have somebody that knows they have messed or tampered with a body, say, look, you're part of this. You can either help us or you can go to jail. Right now, that's not an option. Right now, the same penalty for wiping that fingerprint off of that glass is the same as tampering with the body. Should that be the way it is? I think not. I ask for a yes vote.
Is there any further discussion on Senate Bill 34? Senator Aguilar.
Thank you, Mr. Chair. Members, we did hear this bill in Judiciary Committee. Actually, Senator Kerr got to sit in that day with me. And our initial concern had been, as Senator Stedman had stated about the knowing somebody's intent and what was going on. With the amendment, we actually, in hearing the testimony, thought that a compelling argument was made to say that that moving a dead body was different than moving a glove, and ignoring a dead body was different than ignoring, say, a bloodied glove in a murder. Our initial concern had been the varied levels of felony, as the senator stated, and in listening to him discuss it and the differences in the felonies, knowing that this actually does happen in other sections of law, we were comfortable with that. I do understand now, listening to the testimony, Senator Stedman's concern about the believing that an official proceeding is pending, and wondered just now for the first time whether there's a way to tighten that language up so that we didn't have that same concern about intent. But in general, I'll tell you that the testimony during committee was pretty compelling, that the penalty for helping move a dead body when there's suspicion that a crime has occurred should be held to a different standard than tampering with different evidence. And so I guess what I'm saying is I'm inclined to support his bill. I wonder if there's something we could do to tighten up the language around believing that a crime has been committed, but I don't have an amendment to offer right now.
Is there any further? Senator Stedman?
Thank you, Mr. Chairman. I want to just reiterate a couple points that I think are problematic. And that one is that in order to ascertain the penalty that the person guilty of tampering with the body would be, you must have a charge filed against someone who committed the homicide. Until that charge is filed, this penalty scheme has no way of being imposed. It is dependent upon someone being charged with a certain category of homicide. And so suppose, you know, like I said, I did a really good job of tampering with the body and made it so that you can't know or ever apprehend the real murderer. They never get arrested, they never get charged. Everyone knows I tampered with the body, and there's no way to punish me under the scheme of Senate Bill 34. As a separate objection and as a separate problem that I want to point out to you, some homicides are committed by multiple defendants. And it is entirely possible that not each one of the defendants in the homicide would be charged with the same level of offense because someone may have, for instance, a diminished mental capacity and not be capable of committing a first-degree premeditated murder. And yet one of their co-defendants did exactly that. And so you get a case where the dead body was the result of a homicide where one person is being charged with murder and another person is being charged with manslaughter or some lesser form of homicide because of their diminished mental capacity. So now you have charges of F1 against this defendant and F4 or 5 or whatever it is against another. How does your penalty scheme apply in that situation? This is not a well-crafted bill. It needs to go back to the drawing board.
Senator Scheffel.
Thank you, Mr. Chairman. I move that Senate Bill 34 lay over to February 19th.
Motion before the body is to lay over Senate Bill 34 to February 19th. All those in favor say aye. Aye. All opposed, no. That will lay over till February 19th. Mr. Majors, would you please read the title to Senate Bill 79?
Senate Bill 79 by Senator Todd and Representative Young concerning increasing the alignment of post-secondary and workforce readiness initiatives at the secondary education level with post-secondary career and technical education.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move that Senate Bill 79 lay over to February 19th.
Motion before the body is to lay over Senate Bill 79 to February 19th. All those in favor say aye. All opposed, no. The ayes have it, and that will lay over till February 19th. Mr. Majors, please read the title to Senate Bill 17.
Senate Bill 17 by Senator Neville and Representative Neville concerning allowing a law-abiding person to carry a concealed handgun without a permit in connection with preserving current laws restricting the carrying of concealed handguns on certain property, including school grounds.
Senator Neville.
Thank you, Mr. Chair. I move the Appropriations Committee report.
And the bill?
And the bill.
To the committee report.
Thank you, Mr. President. The committee report from Appropriations.
I appreciate the elevation, but I am Mr. Chair.
I'm sorry, Mr. Chair. The committee report basically stated that there was a reduction in appropriations and 1.4 full-time employees. So this will actually save the state some money.
Is there any further discussion on the Appropriations Committee report? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. All opposed, no. The aye has it, and that report is adopted. To the bill.
Thank you, Mr. Chair. Folks, we're bringing forward constitutional carry, or as many people call Vermont-style constitutional carry. This is the ability to carry a concealed firearm without requiring a permit. The constitutional carry is a basic principle that if you are legally eligible to possess a firearm, you should be able to carry that weapon concealed for self-defense without begging for government permission. Law-abiding people shouldn't be forced to get a government permit before they can exercise their right to self-defense. Constitutional carry simply removes the penalty for carrying a concealed handgun without a permit. This bill is common sense legislation which provides safety for Colorado families and matches the clear intent of the Second Amendment. Friends, open carry is already legal in Colorado. Law-abiding citizens can already carry a firearm openly in most of the state, with the notable exception, unfortunately, of Denver. In essence, the permit requirement is just a tax to wear a coat while carrying your weapon. Constitutional carry does away with the tax or fee and the waiting period to obtain the permit. Constitutional carry does not change current permit system. It merely gives gun owners another self-defense option. A permit would still be an option for those seeking reciprocity while carrying in other non-constitutional carry states. It does not change current reciprocity agreements. Existing reciprocity agreements for permit holders would not be impacted. It passed the Colorado House in 2011 and the Colorado Senate in 2015. Current constitutional carry states include Vermont, which has never prohibited concealed carry, Montana and Idaho, Alaska, Arizona passed this law in 2010, Wyoming in 2011, Arkansas in 2013, Kansas passed the law last year along with Maine. Vermont is consistently rated as one of the nation's safest states when it comes to violent crime, but has never had a restriction on the method of carry of a firearm. Permits don't prevent crime. Criminals don't stop to get a permit before they commit a crime with a handgun, but the permit does keep law-abiding people from defending themselves. Hundreds, if not thousands, of lives have been saved by armed citizens. For example, attempted shootings at the Appalachian School of Law, Pearl High School in Mississippi, and the New Life Church right here in Colorado were all halted by ordinary people. Government doesn't always know best when it comes to training. We don't have training requirements for our First Amendment rights to speak, worship, or assemble, or petition our government, and we shouldn't for your Second Amendment rights either. Constitutional carry states like Arizona and Kansas have seen an increase in voluntary training and voluntary permits since their laws took effect. Government-required training does not take into account the differences between experienced shooters and beginners. No single one-size-fits-all course can do this. Gun owners can and do seek out the training that's right for them without government interference, and instructors should be able to tailor their classes to their students' needs. Friends, I urge an aye vote on this and appreciate the opportunity.
Senator Holbert.
Thank you, Mr. Chairman. Members, I, of course, rise in support of this bill. I was honored to be the sponsor of a bill that the previous speaker mentioned in 2011. That bill, constitutional carry, passed the House on a vote of 40 to 25, with 33 members of the majority and 7 in the minority voting for that bill. The permit system is an expensive, government-issued document for a law-abiding citizen to go out into the public and do nothing wrong. The permit does not allow a permit holder to do anything wrong, brandish, threaten, shoot. It isn't a license to be law enforcement. That permit allows a person to do one thing. In most geographic areas in this state, the permit allows that person to do one thing. Wear a coat, wear a shirt, some article of clothing that covers up the handgun. Because open carry in most geographic places in this state is legal. I am not an attorney. I can't tell you what you can or can't do, but I know that it's legal for me to drive anywhere in this state, including on the grounds of a K through 12 public school campus, and to have a loaded handgun on my hip or in the car with me, under the seat, in the glove box, sitting in the console next to me, in a holster mounted to the dashboard. I know that it's legal for me to go hunting during a hunting season with a valid license and to open carry in that geographic area of that game management unit as long as I am hunting at the time, and to carry concealed with a coat on without a permit. The permit, again, is something that people pay who qualify for it. They take a class, they fill out an application, and between the cost of the class and the application, they pay $300, $400, maybe $500 to get a plastic card that's issued by government that gives them permission to go out into the public arena and do nothing wrong. That is the extent of this permit process. And the good senator's bill would allow people like me to wear a coat without having to pay what we branded in 2011 to be the coat tax, because that's all it is. The illusion that this permit system provides some level of public safety is nothing more than that, an illusion. Does the permit system prevent anyone from carrying a handgun? No. Does it prevent anyone from carrying a handgun open? No. Does it prevent anyone from carrying a handgun concealed? No. People do that without the permit. Criminals do that without a permit right now in this state. So what is the crime? I believe it's a Class 3 misdemeanor. For someone who qualifies for this permit, that means up to 2 weeks or maybe it's 3 weeks in jail. I have never been arrested, tried, convicted. I've never spent a moment confined in a jail. Do you really think that a judge would put someone like me, who's never had an issue, because I qualify? I know I qualify. When I had that bill in 2011, I did not have a permit. Now I do. I didn't need my county sheriff to tell me that I qualify. I already knew that. But now I've paid the coat tax. So now it's legal for me to carry concealed in the state of Colorado. What's it legal for me to do? Have my coat on when I'm carrying a handgun, and to do nothing wrong. There is this illusion, this myth that the permit keeps bad things from happening, and that is not true. Criminals will commit crime. Criminals will go do this behavior without the permit. And all this bill would do is allow people like me to wear a coat while I'm carrying a handgun, and to do nothing wrong while I do it, because having that permit gives permission, gives zero permission for anyone to brandish, display, threaten, shoot. None of that is protected by the permit. It is amazing to me as we debate this bill year after year that people continue to see such a huge issue here. This is such a significant change when it isn't. It is not. It is a minor change. And I appreciate the sponsor pointing out that the accusation that comes so frequently that this is really some underhanded effort to do away with the permit system. No, it isn't. The reason I finally relented and went and paid the coat tax, took the class, got the piece of plastic from my county sheriff, I wanted to carry concealed in another state, and I needed reciprocity. So I went and got the card, and I went and carried concealed in another state, and now I have a plastic piece, another piece of plastic in my wallet that, again, allows me to do one new thing in Colorado: wear my coat, go out in public, and do nothing wrong. I ask for an aye vote.
Senator Jones.
Thank you, Mr. Chair. Members, we heard this bill in committee, and I want to talk about background checks and training. Right now, if you get a concealed carry permit, you need to have a background check. The sheriffs administer those. This year, 98% were prohibited, and 204 may be ineligible. That's 300 people. Now, they don't keep track of why they were rejected, but they're the same reasons that we do for background checks. And in background checks, they denied permits for restraining orders, homicides, kidnapping, sexual assault, robbery, assault, and the list goes on. Those people did not get a permit because they fit one of these categories of somebody who should not have a weapon. So what this bill does, it allows concealed carry for felons in some cases. We're opening up that loophole. Now, this argument that this will do nothing and criminals will still be criminals, sure, criminals will be still criminals, but shouldn't we do something to keep people from having a firearm, somebody who's killed somebody? Really? So it's not going to solve all the problems. These statute books we have, they don't solve all the problems, but we need to do what we can. So that's the background check. This will eliminate the background check. Secondly, training. To get a concealed carry permit now, you have to have a modicum of training. Not much. Testimony said you don't even have to go out on a live fire range. A woman who got a concealed carry permit that did go out on a live fire range said this, because some classes have that with it, said that the instructor spent most of their time trying to keep the muzzle of the gun away from them, the people were so inexperienced with a firearm that they didn't know not to point it at their instructor. I don't think those people are going to help people in a live fire situation. I think they're probably going to do more harm. So the bottom line for this is this makes Coloradans less safe. It gives people firearms that shouldn't have them to carry concealed. And it gives no training to somebody to carry a firearm concealed. So we should do what we can to limit violence in Colorado. No, it's not going to solve all the problems, and that seems to be the standard. That's a silly standard. If we had that standard, we wouldn't have half the things in our statutes. But this will protect, to some degree, Coloradans and have the wrong people, not have the wrong people carrying concealed, and will also include a little bit of training for somebody to conceal carry. That is a pretty low standard as it is. And now we're just taking that away completely. I just don't understand it. I ask for a no vote on this bill.
Senator Stedman.
Thank you, Mr. Chairman. Colleagues, I rise to object to Senate Bill 17, and in particular, to object to the idea that this bill enacts a policy of what's called constitutional carry. And I do so on the basis of the Colorado State Constitution. I'd like to read from the Colorado State Constitution just briefly. It's a single sentence. It's found in Article 2 of our state constitution, our Bill of Rights. It's section 13, and it is captioned the right to bear arms. And it reads as follows: the right of no person to keep and bear arms in defense of his home, person, and property, or in aid of the civil power when thereto legally summoned, shall be called in question. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons. This is part of the original state constitution as enacted in 1876 when Colorado became a state, and it has never been changed in almost 140 years since. There is no constitutional right to carry a concealed weapon in our state. The founders of our state constitution expressly excluded the right to carry concealed weapons from the scope of the right to bear arms that's protected by our Bill of Rights. The right to carry a concealed weapon is not a constitutional right in this state. It is a right granted through statute, through state law, through this General Assembly. And we have passed laws to create a permitting system that enable people to legally carry a concealed weapon in our state. The Constitution leaves that discretion and the power to regulate and control the carrying of concealed weapons to the General Assembly. That is clear. Now, I am not asserting that Senate Bill 17 violates the Constitution. This is clearly one of the ways that the General Assembly might choose to extend the right to carry concealed weapons, to do it without permits, without safety training, without background checks. That's a choice we can make. I think it's a terrible choice, and it's certainly not one with its roots in our Constitution. I think the founders of our state constitution would be shocked by Senate Bill 17. I'll be voting no.
Senator Holbert.
Thank you, Mr. Chairman. I appreciate the opportunity to respond. And I have the highest respect for the previous speaker, the good senator from Denver. This is a question that comes up frequently in debate on this, and that specific sentence, nothing herein, that is in our Constitution, but let's be careful that we understand what that says and what it does not say. Our state constitution does not prohibit concealed carry. Those words in the Constitution say that nothing therein in that sentence, in that part of the Constitution, nothing therein defines it. Nothing therein justifies. Nothing therein actually prohibits it either. That is why we have a permit system in this state. And to label this, to subtitle this bill, as it has been in prior years, constitutional carry, I believe points to that higher constitution, the U.S. Constitution. The Second Amendment says that nothing that we do should infringe on that right for people to keep and bear arms. And this is not the keep part, but the bearing of arms. Again, in this state, under the Constitution and our statutes, in most geographic places, for instance, outside of the home rule city that is the city and county of Denver, in most geographic locations in the state, open carry is legal. So if there was some prohibition on putting on your coat, I think that the founders, the writers of our state constitution would have taken that a step further and not just said, nothing in here really addresses concealed carry. They would have taken that a step further to say, for whatever reason, that concealed carry is outlawed, unconstitutional, banned, not allowed in this state. But that's not what our state constitution says. And the prior speaker is absolutely right. The state constitution allows the statutory provisions that the legislature has put in place, that a previous governor signed into law, and we have a permit system that is constitutional. And I'm a yes vote on this bill because if it passes, I believe it honors that higher constitution, the U.S. Constitution, and in my opinion, in no way violates our state constitution. It is a question that has come up before, and some have challenged, is concealed carry constitutional? And I'm not suggesting that the prior speaker made this suggestion. He did not. And that's right, because our state constitution doesn't prohibit this. The wording says, nothing there defines it. Ask for an aye vote.
Senator Merrifield.
Thank you, Mr. Chair. The previous speaker made reference to the U.S. Constitution. So in this week when we are honoring one of the most astute constitutional scholars, former Justice Scalia, I'd like to point to something that he said concerning this subject, which is, I quote, "One final point I'd like to make. In 2008, sorry, I'm not quoting him yet. In 2008, the U.S. Supreme Court heard the District of Columbia versus Heller, and it focused on the District of Columbia's handgun laws and whether it was constitutional or not. And one interesting thing that came out of that decision was Justice Scalia's opinion, which is, quote, the following. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone to the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever or for whatever purpose. For example, the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. Nothing, in our opinion, should be taken to cast doubt on the long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions upon and qualifications on the commercial sale of arms. Considering that this opinion came from one of the most conservative justices and educated justices on the U.S. Constitution, I think it's important that we note that when we look at consideration of this bill.
Senator Cook.
Thank you, Mr. Chair. I rise in support of the bill. I wish the good senator from Douglas County would have left some talking points for the rest of us that agree with this, but he said most of what I think all of us wanted to say. But let's talk about the backgrounds that were brought up from the senator from Louisville, or Lafayette. The background checks. He mentioned that people were turned away for kidnapping because they couldn't get a permit because they had a conviction for kidnapping. Well, it's already illegal for them to carry a firearm, to own a firearm, to have a firearm. So we're not stopping them. They went and got a permit, or tried to get a permit, but obviously they had a gun already. Now my question is, how much has CBI gone, and or the state patrol or whoever, or Department of Homeland Security, how much have they gone to try and find that guy and charge him with having a gun illegally? I don't think we find very many stats on that. Let's talk about the training. 3 hours is all that's required. And you don't even have to go shoot. You can do it at a classroom, learn about the law, and you can get a permit. You don't need that for open carry, which is other than Denver, which has been brought up, is perfectly legal. This system won't do away with the concealed carry permit process because, as the fine senator from Douglas County said, he wants reciprocity and be able to go to other states. If we look at the CCW law now, you don't need a permit if you're in your house. You don't need a permit when you go to your car. You don't need a permit when you go to your business. You leave your house and you step out onto the street to get into your car, you've just committed a crime. You go and you drive to your place of business and you get out of your car and you walk to your place of business, you just committed a crime because, as the senator from Douglas County calls it, a coat tax. So now you're a criminal when you leave your house and when you leave your car to go into your business. That doesn't make sense. I've heard that having constitutional carry is a peace officer safety issue. It's not. County sheriffs of Colorado, the chief law enforcement officials of the counties, support this bill. It's not a matter of peace officer safety because when you contact somebody, you're going to have to assume everybody is carrying a gun. Universal precautions. You just have to assume that somebody has a gun. Now, if you contact a law-abiding citizen and they have a firearm, there's not an issue there because they legally can have a firearm under this bill. You contact a criminal and they're carrying a concealed carry, they're carrying it illegal, they're already committing a crime, now they're committing another. You just have to assume anybody you contact is carrying a gun. This just makes it easy for people who are law-abiding citizens to carry, conceal in their communities, to make their communities safer, which I believe this bill will do.
Senator Merrifield.
Thank you, Mr. Chair. I just would like to add that in 2003, when the original concealed carry bill was drafted and passed, I was one of the members who had the opportunity to be involved in the drafting. And we, as you have been told, we placed some restrictions on concealed carry that at the time when we passed the bill, I remember the NRA slapped me on the back and thanked me for being involved in these reasonable controls upon concealed carry. I'm not sure what has happened in the years since 2003 to make a difference. I think we created a reasonable bill that is not illegitimate, that does not create unnecessary hardship on those who wish to have a concealed carry weapon. And I think we should maintain that law as it's currently in statute. So, thank you very much.
Is there any further discussion on Senate Bill 17? Senator Donovan.
Thank you. I rise in opposition to SB 17 today. Gun owners are responsible people. Most take a hunter ed course online with a full day in-person course or even follow up with additional education after that if they're going to pursue even species-specific hunts. We learn the do's and don'ts of handling guns. Those that pursue a concealed carry permit take in-person classes that can last a day or even a weekend long in some cases. I'm a gun owner, and like so many Coloradans, I take our education and firearm training very seriously. As one concealed carry instructor put it, we believe that in this society, everyone is safer and better prepared by obtaining as much education, training, and knowledge as possible. While this bill eliminates training for concealed carry, it also sends a message that we don't need, nor do we value education as part of gun ownership. It sends a message that just the act of buying a gun makes you capable of using it. Just the act of buying a gun makes you capable of using it. This is in stark contrast to everything I've been taught by my grandfather, who was career Army, and what I was taught by my father, who is a lifelong sportsman. It sends a message that the safety standards gun owners believe in should just be thrown out the window. This bill seems, for that reason, extreme and out of touch with what the majority of law-abiding, responsible gun owners believe, and that hurts the reputation of sportsmen across the state, as well as those who are proud to have the education and training that makes them responsible carriers of guns. This is not the tradition of gun ownership that I and other Coloradans were raised with. Concealed carry is a high standard to meet to earn the opportunity of carrying a weapon. The classes teach you basic skills, but they also teach you about liability, laws, and the rights of gun owners. This is not something we should try to be lessen or even providing an opt-out. This is critical knowledge for gun owners to learn and to continue to strengthen the message that education is foundational to the heritage of gun ownership in this state. I ask for a no vote.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 17 to February 19.
Motion before the body is to lay over Senate Bill 17 to February 19th. All those in favor say aye. All opposed, no. The ayes have it, and that will lay over to February 19th. Majority Leader Scheffel.
Thank you, Mr. Chairman. I move the committee rise and report.
Motion before the body is for the committee to rise and report. All those in favor say aye. All opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come back to order. Senator Grantham.
Thank you, Mr. President. The committee has had several bills under consideration. Mr. Majors, would you please read the report?
February 18, 2016, Mr. President, your committee whole brings the report is under consideration. The following attached bills, being second reading thereof, makes following recommendations thereon. Senate Bill 34 is amended. Senate Bill 79, Senate Bill 17 is amended, laid over until February 19, 2016, retaining the place on the counter. Senate Bill 7 laid over until February 23, 2016, retaining its place on the counter. Senate Bill 121, as amended, lost on second reading.
Senator Grantham.
Thank you, Mr. President. I move the committee of the whole report.
The motion before the body is the adoption of the report of the Committee of the Whole. There is an amendment. Mr. Majors, would you please read the title? Read. Amendment 1.
Whole Amendment 1 to Senate Bill 121. Senator Tate moved amendment.
Senator Tate.
Thank you, Mr. President. I move the Tate amendment to the report of the Committee of the Whole and ask for a aye vote. Thank you.
Well, that was a fascinating explanation. Thank you for that. Time out. How many degrees? The motion before the body is the adoption of Amendment 1 to the Committee of the Whole report. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, Committee of the Whole Amendment 1 is adopted. Now the motion before the body is the adoption of the report of the Committee of the Whole. Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the report of the Committee of the Whole is adopted. Senate Bill 121 is amended, passed on second reading, and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 34 is amended, Senate Bill 79, Senate Bill 17 is amended, laid over until February 19th and retaining their place on the calendar. Senate Bill 7 laid over until February 23rd and retaining its place on the calendar. Message from the Governor.
February 18, 2016, Colorado Senate. Ladies and gentlemen, I have the honor to inform you that I have approved and returned the following to the Secretary of the Senate. Senate Joint Resolution 3 concerning approval of water project revolving fund and eligibility list administered by the Colorado Water Resources Power Development Authority, approved February 18, 2016 at 10:34 a.m. Sincerely, John W. Hickenlooper, Governor.
Colleagues, we're going to move to announcements and then we're going to adjourn shortly, but I did want to take a moment to recognize officially, as if you didn't already see them sitting next to you, our special guests. It's been a real privilege and honor to have them joining us today. Some of us, I know, were honored to be in their seats, not in here, but as members of gifted and talented programs. You know who you are. It'd be great if we knew who you were. And we are sure that some of you will honor us with your presence in our seats one of these days as you run for office and serve and share this tradition with those who follow. It's been a privilege to have you. We hope you learned as much from us as I'm sure all of us learned from you. So we want to thank you for joining us. Announcements. Senator Grantham.
Thank you, Mr. President. Request a moment of personal privilege.
Granted.
Thank you, Mr. President. Colleagues, I have the honor to introduce someone from Canyon City here today. I served with her on the Canyon City Council and also served at the same time as I was the Republican county chair. She was the Democrat county chair. And I know this might pain some of you. It might actually make some of you feel much better about the day, but this lady over here is my favorite Democrat. And I'd like to introduce Pat Frieda from Canyon City and welcome her to the chambers today.
Senator Cook.
Thank you, Mr. President. Request a moment of personal privilege.
Granted.
Thank you, Mr. President. The North Metro Chamber of Commerce was down here joining us on the floor for quite a while, but they had to leave. But a member of that is remained, and I'd like to introduce my son, John B. Cook the fourth. So be scared, be very scared. There's two of us running around the building today.
Senator Lundberg.
Thank you, Mr. President. Just briefly make the members aware that it's a Physician Assistant Day at the Capitol today as well. So if you see any of those folks, greet them. They're probably one or two, might be from your district. Thank you.
Senator Baumgardner.
Thank you, Mr. President. A couple things, members. The Gifted and Talented Lunch is across the street at noon at the Masonic Temple. Also, the Sportsman Caucus is going on at the same time downstairs, so you're going to have to pick. Thank you, Mr. President.
Senator Donovan.
Thank you. Two announcements, colleagues. Tomorrow, I would like to remind you that we will be talking about and raising awareness of heart disease. So if you can join me in wearing red to acknowledge that item that we will be discussing. Additionally, I would like to invite you all to Geothermal in Colorado, and you all got a flyer on your desk. At 7:30, there will be breakfast there. We would love to all have you there. This has been a project that's been in the works over the summer working with Representative Wilson over in the House, trying to bring some subject matter experts to talk to you and learn more about geothermal opportunities in Colorado. So hope to see you all there, 7:30. Thank you.
Senator Todd.
Thank you, Mr. President, and I would like to ask you to please help me join in welcoming Tom Tobiasen, who is the chair of the directors of RTD for the state of Colorado.
Further announcements? Senator Guzman.
Thank you, Mr. President. I just want to remind everybody that the wonderful Adams State University is in town today and tonight and tomorrow. They have a reception at the Denver Warwick Hotel beginning at 5:30 this evening. I hope everybody will join us there to welcome this phenomenal academic institution in Colorado.
Senator Tate.
Thank you, Mr. President. Just an announcement that today at noon in LSBA is the Claw Caucus. Please join me and as we learn about animals. Thank you very much.
With no further announcements, Senator Johnson.
Thank you, Mr. President. I just would ask after Senator Grantham's announcement this morning, if you could just remove me as a co-sponsor from any of his bills, that would be great.
Senator Johnson's bills will all be assigned to State Affairs. Psychic. Further announcements, real announcements. Majority Leader Shuffle.
Thank you, Mr. President. In the absence of any further announcements, I move that the Senate adjourn to 9 a.m. Friday, February 19th.
You've heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it. The Senate will be adjourned until 9 a.m. Friday, February 19th.